Go ahead.
Your Honor, today is the date and time set for probable cause conference in this matter. I know the court would want to first address Mr. Rainey's bond violation.
Yes.
I know. So, Your Honor, Mr. Rainey was released from custody. I don't have the date in front of me. However, upon his release, Your Honor, he
left the state.
He did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing. Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to
I
go.
ended up getting in Litchfield one day.
Okay. He indicated that he was
You
only
need to take your hands out of your pocket.
He indicates that he was only in Indiana for 1 day. He has been back now.
1 day too long.
1 day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield,
Michigan, where I'm from.
in Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously.
Buckle up, guys. Today we're stepping into a tense courtroom where every excuse is about to be tested. Right from the start, Mr. Rainey's case grabs attention. A man accused of breaking bond and crossing state lines. His attorney pleads that it wasn't disrespect but desperation, explaining he had nowhere to go. Yet the judge's sharp tone makes it clear. Sympathy won't erase the fact that even one unauthorized trip is a serious violation.
We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
No, he knew then.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact. And I apologize.
No, you didn't contact everybody you could have contacted. And you didn't get a response. Any response from the people?
Okay, the concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else, he was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not. But the issue is, he's on bond for a CCW at the time of this possession case. He leaves the state. And I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And there are, clearly had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was gonna follow the bond conditions that were set by this court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she...
As the exchange continues, the courtroom tightens. Rainey insists he try to reach out for help, but the judge cuts through every excuse with precision. You knew then. The judge reminds him, and that single line hits hard. His defense pushes for another chance, citing months spent in custody and efforts to stay clean. Still, the reality stands firm. The bond violation cannot be undone. By the end, Rainey is remanded, his second chance slipping away.
forwarded the testing results to community correction. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's orders. It's really simple. Anything else?
Like I said, I got a place here.
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time, the defendant's remanded on the warrant. Community correction for violation of his bond.
Thank you, Your Honor.
Next, the focus shifts to Desiree Badnovich. And this time, the problem isn't defiance, it's disconnection. Her public defender struggles to reach her behind bars due to holiday delays. The defendant's frustration boils over as she claims she waited hours by the phone with no call. The judge tries to calm both sides, pushing the next hearing 2 weeks out. It's a reminder that sometimes justice stalls not from neglect, but from pure system overload.
Case People versus Desiree Badnovich.
Yep, right here.
Okay. Hello.
John Rob Chico on behalf of Ms. Bogdanovich. Judge,
Badnovich.
we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have an in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms. Bogdanovich, no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they told me.
I've been sitting in front of the phone for 4 hours waiting for you to call on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay.
tomorrow, 10
Hold on. He's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
Okay.
All right. So probable cause conference, I'll adjourn it. I have to go 2 weeks out. I would put it 1 week out, but we have to do the whole writ procedure to get you before me. So I'll go to the 23rd, the next day that I can possibly do it.
That's fine, Judge.
2025 at 9. Bond in this case will continue.
Thank you.
Okay? Thank you, ma'am.
Then comes one of the most heated exchanges. Zachary Amy's attorney argues his client's staggering $3 million bond was set without fair hearing or access to evidence. The judge listens, firm but open, demanding a written motion and setting the next date. When the prosecutor mentions missing discovery due to locked devices, it sparks tension. Accountability meets technology. This is justice in the digital age, where even passwords can determine a man's fate.
The time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just to let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the...
Well, there's a couple of reasons for it. One, obviously the limited contact that I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and the $3 million bond was put into place. And at that point,
All right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
Never.
But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yes, Your Honor.
But the only thing, I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't, if you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on.
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
Set probable cause. I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m.
Finally, the courtroom moves to the remaining cases, including one so disturbing it silenced the room, and another where a quiet defendant waived his hearing, accepting the process. These moments show the wide reach of justice, from pleas for mercy to acceptance of fate. Each case carries its own truth. Excuses crumble, emotions clash, and law prevails. And that wraps up today's session. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.